Hello, thank you all so much for having me. It's a pleasure to be here. My name is Themba Lewis, and I am the Secretary General at the Asia Pacific Refugee Rights Network, based here in Bangkok. I'd like to thank the hosts, the Dongcheon Foundation, the Korea Refugee Rights Network, and UNHCR for inviting me to give a bit of a background on the current context facing refugees and asylum seekers in this region. I'll say a few words about the Asia Pacific Refugee Rights Network, just to contextualize who I am and what has brought me to this seminar. And then I'll say a little bit about the development of the international refugee rights regime. Asia Pacific Refugee Rights Network is a network that came into formation about 11 or 12 years ago through a few dedicated refugee rights advocates in the region who gathered to recognize that refugees, by their very definition, are an international concern. A refugee isn't a refugee unless they cross a border. So by their definition, multiple states are involved in refugee rights and refugee rights defense. And those individual pioneers of the Asia Pacific Refugee Rights Network determined that the best way to promote refugee rights across Asia and the Pacific would be to work collaboratively across those borders to increase access to information, to build the capacity of any number of small refugee rights advocacy organizations, law firms, and individuals, and also to work together to advocate jointly at a regional and at an international level to make sure that we are building a strong foundation for refugees in this region. We now have grown to very considerable size. We have about 440 organizations and individuals who are members of our network, and they are dispersed across a very diverse geography and set of contexts and set of challenges. I'd like to begin by providing a little bit of context to the development of international refugee law. Then I will go into the particular circumstances that face refugees here in this region. I'd like to start by grounding this discussion in law. One of the things that strikes me about refugee rights and human rights in particular is that there's only one system to which rights are accountable, and that system is legal. The law is the foundation for all rights, and refugee rights are no different. States are required to uphold the rights of their citizens, and through law, those rights can be defended, challenged, and advanced. The problematic is that refugee law, even now, is in its infancy. But the 1951 Convention is a very comprehensive legal document that most importantly spells out who a refugee is, what the criteria are for becoming a refugee, and what rights refugees should be afforded in countries of exile. This posed a problem because rights, as I mentioned, are the responsibility of a state towards its citizens. Refugees pose a dilemma. Refugees are not citizens of their host state, and often host states feel no responsibility to protect rights of non-citizens. The convention spells out what is probably the most important and fundamental of refugee rights, and that is protection from return to a persecutory authority. That means that if you are able to satisfy the criteria laid out in Article 1, defining a refugee, then you should be entitled to the rights that follow. And the most important, as I mentioned, is the article that defines non-refoulement, which means that a person facing persecution cannot be sent back by any means to a country where there is a risk of serious violations of their rights and persecution based on one of 5 different grounds. Just briefly, they are on the basis of your race, your religion, your nationality, your political opinion, or your membership in something that they termed a particular social group. And once you've satisfied the criteria and you can demonstrate that there's a nexus with persecution, you are then to be declared a refugee. And as a result, you should be able to enjoy the subsequent rights. Some of those rights include right to work, right to education, right to livelihood, family unity. Importantly, a right to enter a country without documentation. We often see refugees criminalized for entering illegally into a country, but this is not actually the case under law. refugees are afforded the right to enter any country by any means if they are fleeing persecution. Now, it does get quite complicated. Refugees often utilize challenging routes in order to enter countries, especially if they don't have documentation. And there are, of course, thresholds around the ability to claim asylum and how you get to a place of exile and protection. Refugee law itself is one of the most complicated areas of international law on the planet. It combines criminal law, immigration law, human rights law, often maritime law, and domestic legislation in order to create what is an imperfect structure, but a structure nonetheless aimed specifically at providing rights to populations that are not citizens of a hosting country. Notably, Korea has signed the 1951 Convention and also has put in place the first refugee law in all of Eastern Asia. And I commend very much the government of Korea and the people of Korea for advancing refugee protection in that way. We now stand in a region that, if you consider all of Asia and the Pacific, a region that has the fewest instruments of refugee protection in the world. There are some states in the region that have domestic refugee legislation. There are some very few states in the region that have signed the 1951 Convention. But the vast majority of states in this region do not have any domestic legislation that protects the rights of refugees. This can be very challenging, of course, and lawyers have looked at alternate instruments in order to protect refugees. Of course, the 1984 Convention Against Torture also underscores the non-refoulement principle, the restriction on a state's ability to return someone at risk to a country in which they are at risk. But other than that, there's really been a patchwork across the region of legal instruments that are used to protect refugees from return. What refugees face upon return to a country they fled should not be underestimated in terms of its violence, in terms of its potential to cause further disruption and war, in terms of its potential to tear apart families and economies. Refugees, like all of us, are just a cross-section of people who have been forced out of where they live due to the circumstances of their situation. Those circumstances are not of their own choosing. And therefore, it is quite dire, the fate that awaits many refugees, if indeed they are returned. This principle of non-refoulement that I mentioned, it's very comprehensive. It also means not only that if a refugee comes and applies for asylum, that their case should be heard and adjudicated. And if they're determined to be a refugee, they should not be sent home. But it also prohibits the return of refugees in any manner whatsoever, to quote the convention, to a country in which they face persecution. That could mean the sending of refugees to a third country for the adjudication, which we've seen Australia do. It could also mean the refusal to allow refugees onto your territory, to refuse access. And we've seen that most recently here in Southeast Asia with boats of refugees from Myanmar trying to disembark in Thailand and Malaysia and being turned away. All of these can be considered violations of international customary law and that fundamental principle of non-refoulement. So we have a long way to go. But I will begin a little bit by contextualizing the situation here in Southeast Asia and East Asia particularly, to provide a little bit of an overview of what refugees we're talking about and why it's important that we work through the legal systems to build protective legal precedent to enforce and develop refugee protection through law. Now, in the present day, the largest and most recognizable refugee population in our region is, of course, the Rohingya population. The Rohingya are a Muslim population from Myanmar who have been driven out of Myanmar over the course of decades. But most recently, we saw a major outflux of Rohingya due to increased fighting in Arakan state in Myanmar 3 years ago. And that outflux has created a series of refugee camps in Bangladesh around Cox's Bazar, and has led to a number of onward movements of refugees, including those I mentioned earlier, who've traveled by boat out of Bangladesh and out of Myanmar down the coastline, trying to find protection in countries that either provide a more welcoming atmosphere for refugees, or perhaps where refugees have family connections, or perhaps where refugees have heard that their prospects of gaining more substantive protection are greater. We also shouldn't underestimate the human capacity to pursue livelihoods, and refugee camps don't afford opportunities for refugees to do that. Refugee camps are closed, confined spaces. Refugees in camps very rarely have access to education or access to employment, and often are at great risk, including now during the time of COVID, when refugees are in situations where they're not able to socially distance, they don't have appropriate information about healthcare and preventative measures, and where access to hospitals and medical facilities can be very, very limited. Let's also not forget that the majority of refugees do not live in camps around the world. The majority of refugees live in urban settings where they've blended into cities and create their own economies, livelihoods, and systems of support. Refugees don't choose where they get to go. Most often, refugees have very, very little time to flee a country. Oftentimes, they flee to the closest possible safety. Sometimes the closest possible safety is not a neighboring state. Sometimes those states can be quite distant, and sometimes those determinations are based on where a refugee might be able to actually access a legal system, where a refugee might be able to get a visa to fly into a country, for example. As restrictions have grown, this becomes more and more difficult, especially during the time of COVID, when borders are closed. That fundamental right to seek asylum, which is Article 14 of the Universal Declaration of Human Rights, has been abridged by this process. So the time to work towards ensuring refugee rights is now. The need is greater than it's ever been, and the refugee populations around the world are larger than they've ever been. In addition to the Rohingya, we see large numbers of Afghan refugees still displaced across the region. We see refugees in Sri Lanka and India. We see refugees in Indonesia and Malaysia and Thailand. We see refugees in Japan and Korea and Taiwan. And we see many refugees working to make their way to Australia. No one puts their children in boats. No one hands their loved ones to smugglers or traffickers. No one risks their lives without having a very good reason. And without refugee law, without protections for refugees, those dangers don't necessarily disappear upon arrival into a hosting country. So people will come to countries like Korea because they've heard that it has a legal structure. Perhaps they know people who've been granted asylum in Korea. Perhaps through the grapevine they've heard that they may have the possibility of being granted asylum in Korea. That's not the case in Thailand. It's not the case in Malaysia. It's not the case in Indonesia. Countries that have legal systems have avenues for refugee rights protection. And it's not easy to become a refugee, to be declared a refugee. The system that determines who is a refugee, the legal definition of a refugee, is not easy to fulfill. You need to provide evidence. You need to provide proof that you are individually targeted. You need to have a very good memory of events. You need to be very consistent in what you say so as not to be accused of trying to manipulate the asylum system in order to seek simply a better life. When refugees arrive in hosting countries, much of the time they will be intercepted by the authorities of those hosting countries. And in increasing numbers, refugees are put into detention centers. These are administrative detention centers. They operate outside of criminal law. So the protections that a prisoner would have are often greater than the protections that a refugee seeking asylum would have, someone who's broken no law, someone who's simply seeking protection. We see the growth of these reception centers, as they're sometimes called, in almost every country in the region, and certainly in Europe, in the United States, in Australia, where the history is quite long. These detention centers challenge access to fundamental rights because they challenge access to the law. They challenge access to evidence gathering. They challenge access to legal representatives. and they challenge some of the basic access to information that refugees need in order to claim asylum. If you were to cross a border next week because a war broke out, would you know how to claim asylum in another language, in another country, before armed naval officers? These are only some of the challenges that refugees face getting to where they're going. When we look at contributions refugees have made to economies, to societies, we can only see positives. If integration is done well, refugees can contribute to their economies, they can bring fresh thinking, they can bring skills, they can bring ideas, and they often are very, very genuine contributors to those economies and societies. So refugees themselves, while often called a burden, are usually only called a burden by state actors for political gain. Refugees in the history of the evidence demonstrate positive net gains for hosting societies, and I think it's very important that we remember that as an additional reason that we should be working towards refugee rights. In addition to the fundamental moral humanist reality that we are all humans and that universal rights should be universal. So even if you do not have a state any longer, that your rights should be upheld. And that's the fundamental core of international refugee law. How we treat refugees demonstrates what we believe humans to be. How we treat refugees demonstrates where we fail in protecting other human beings. And so I commend those of you, legal advocates, interested academics, practitioners, and others who find yourself curious about how we might better the system for refugees and people fleeing persecution. Refugees are not able to represent themselves, and therein we find a failure of due process. So I again commend you all. I hope this seminar is enriching. I'm sure it will be. I welcome any questions during the question and answer session, and I welcome any follow-up that anyone might have, either to me directly through my contact information, which I'll ask the moderator to share, and I look forward to any further dialogue. Thank you so much.